All right, Widener. Boy, there's a lot of people sitting out there. Some people are only signed in with their first name. What's her first name?
Karen, I don't think she's actually in the waiting room, but I know that she was going to watch the live stream, and I can tell her to hop on Zoom real quick.
All right, it is live streaming now. And let me see, I'm going to get the parents in. And as soon as we do that, I'm pretty sure I saw Mr. Bradshaw. It's possible he's with Ms. Eubanks. Let me find out. Good morning, Ms. Eubanks. You can hear me?
Yes, I can.
Is Mr. Bradshaw with you?
Yes, he is.
Okay. All right, I'm looking to see if there are any other parents in the waiting room. It doesn't look like it.
Excuse
One
me,
more.
Judge LaFlamme.
Yes.
Samuel is still in the waiting room, he said.
Oh, okay. I thought he was with you. Pardon me. Is he with a phone, a device that he didn't log in on?
He's
Or
on
a
the same,
telephone?
he's on a cell phone, the way we always log in.
It would be an
Well, yours,
number, Your Honor. 517-867-93. Oh, wait, that's not it.
No.
517-395-1126.
Yes.
I don't see that number. I see a Galaxy S8. Let me see who that
That's
is.
him.
Oh, okay. Yes, that's Mr. Eubanks. Good morning, Mr. Eubanks.
Bradshaw.
I'm sorry, Bradshaw. I knew who you were. I got the wrong name. All right, hold on. All right, and now I'm going to scroll through one more time. There are a lot of people here today. I know that Ms. Brianna Johnson has participated in the past. I just wanted to make sure whether she's here. All right, I've got a few that just have devices, so I'm going to find out who they are.
Hello?
Hello?
Yes, sir, you're identified as a Moto E6. What is your name?
I'm Keegan Lovett. I'm father, and then I have mother Veronica Russo with me.
Oh, okay. Hold on just a minute. I'm gonna put a name with your screen so I know who you are, and then I'm gonna put you back in the waiting room. 'Cause
Okay,
we're not
sir.
quite ready.
Okay. I don't like that it goes to that call thing. Is that because I did call over the internet? Oh, there we go. Hey, there's Rebecca.
Okay, now at least I know who you are. And we'll
Yes,
put you
sir.
back in the waiting room.
Okay, Your Honor. Thank you.
You're welcome. Oh, oops, looks like somebody else ended up going back in the waiting room. Let's see, telephone number ending in 6931. What is your name?
Denisha Ostrander for Barnett's case.
Okay, I'm gonna put you back in the waiting room.
Okay, thank you, Your Honor.
You're welcome. And finally, telephone number ending in 1309. What is your name?
David Barnett.
Okay, Mr. Barnett, I put a name with your screen, and I'm going to put you back in the waiting room.
Thank you, Your Honor.
All right, and I'm afraid I may have put somebody in there inadvertently. Let me just make sure I didn't lose someone. And you said Ms. Wiedner or Widener, I'm not sure how to pronounce it. Correct, Michelle?
Yes.
I saw that she showed up in the waiting room, so I'm bringing her in. All right. I think we finally have everyone here. Shannon, put us on the record, please. All right, we are on the record in the matter of the Bradshaw minors in file 21-15 and the Eubanks, Bradshaw, and Lewis minors in 15-493. So I'm going to ask, we have Kelly Tucker here for the petitioner. I'm going to ask the other attorneys. Well, Mr. Brown is LGAL on both files. So now if we could have the other attorneys who represent parents identify themselves and then who you represent.
Rebecca McCluskey for Yanessa Eubanks.
Michael Kelly for Samuel Bradshaw.
Yes, Mr. Bradshaw is present. Ms. Eubanks is present. And we have workers Emily Schell, Schell, and I don't have a first name, Widener, Weidner. I'm sorry, what's your first name?
Taryn.
Karen.
Aaron.
Taryn with a T.
Taryn. Okay. Okay, we're scheduled for a pretrial today. I spent some time off the record with the attorneys to figure out whether we're anywhere close to being ready for a trial, and it appears we are not. Mr. Kelly has requested that I order psychological evaluations for Mr. Bradshaw and Ms. Eubanks. Well, he requested for Mr. Bradshaw. Ms. McCluskey requested for Ms. Eubanks. And there's no opposition to that request. So I am going to order psych evals be provided to these two parents by Dr. Rickman. There was also a request for obviously an adjournment because there's going to be significant time required in order to get up speed on the file. But there was also a request that I authorize Dr. Gurton to be hired to perform an independent review of the medical records and offer an opinion as to whether or not he sees evidence of child abuse. And there's no opposition to that request either, so I'm also going to grant that request. I'm going to adjourn the pretrial for 4 weeks. And we'll see where we are in 4 weeks. I think that's probably optimistic to think that we'll be ready in 4 weeks, knowing how long it takes to arrange for these things. But I would like all diligence used so that we can expedite this. I realize all but 2 of the children are in home, but those 2 children are with a relative. So at least we're not battling children placed with strangers. But let's see where we are in 4 weeks. Shannon, what would that date be?
23rd at 8:30.
March 23rd at 8:30, where we'll continue the pretrial and see where we are. And I believe the only other matter, excuse me, was the issue of Mr. Bradshaw's parenting time.
Your Honor, if I could address a couple of things that you've already brought up. In relation to the psychological evaluation with Dr. Rickman, I would just request the court include in its order that the parents' attorneys are allowed to assist in the drafting of the actual referral form. We've done this plenty of time in the past. If we can work with Callie to get the referral drafted so that Dr. Rickman knows what he's supposed to be looking for and the questions he needs to answer. Secondly, in regards to the medical records, I'm not sure of Miss McCluskey, but outside of what looks like a record from Mott's Hospital, I do not have any medical records from Henry Ford Allegiance or from Med Express. And I had a request for medical records in the discovery packet provided to me by Mr. Way for Center for Family Health, but it doesn't seem like there was any records included. That was dated late January, so they may still be waiting on those records. So in ultimately getting our matters to Dr. Gurton, I'd request assistance of the court as well as the agency in getting all these medical records together, because I don't think we're limited just to what happened at Mott. I think we need to look at the history here, because there's a question of anemia in relation to this child. That doesn't sound like it was acute. It sounds like it was chronic. And that I think is important for the court to be aware of, and also for Dr. Gurton in his review of the medical records to provide an appropriate opinion for the court. So outside of those 2 issues, if the court's prepared, I would like to address parenting time as it relates to my client, Mr. Bradshaw, with his children.
Yes, I'll order that the parents' attorneys are to be consulted concerning the referral order for Dr. Rickman's psych eval, that complete medical records from all medical providers need to be produced. So go ahead with your request regarding parenting time, Mr. Kelly.
Your Honor, as the court's aware, under the statute and court rule, MCL 712A 13A13, from preliminary hearing to adjudication, supervised parenting time should be ordered unless the court can make a determination that even supervised it may be harmful to the child's life, physical health, or mental well-being. If it's the latter, inappropriate, as it relates to their mental well-being, the court can order to have the child to undergo a psychological evaluation or counseling or both to determine the appropriateness and conditions of parenting time. At this point in time, Your Honor, my client only has parenting time with his daughter, August. I'm not sure, I'm not quite clear if that's in person or if it's simply via Zoom. But I would request of the court that he be allowed to have parenting time with all of his biological children. Not only the 2015 493 file that has Kylene and August in it, but also in the 21-15 NA file with those 3 children who are 12, 6, and 5 that he had custody of up until July of this year before all the things started happening with DHHS. He has advised me that he has been contacted by his oldest who misses him and would like to see him. And he did not violate the court order. He talked to his caseworker about it, and she had indicated appropriately so. You have a suspended parenting time order. You can't really have communications. So we're bringing this issue to the court this morning. And I think appropriate safeguards can be put in place, certainly if parenting time is still being done over Zoom for his children, but even if it's in person and it's supervised by the Department of Health and Human Services only, I think appropriate safeguards can be put in place for him by himself to be able to visit with his 5 children. Thank you.
So before I talk about the merits of whether Mr. Bradshaw should be afforded supervised visits, I just want to make sure I'm clear. My understanding is that if the petition requests termination, that whether or not parenting time is authorized by the court is discretionary with the court. Am I mistaken about that, Mr. Kelly?
I'm pulling up the bench book as we speak to make sure of that. The language used is may. It doesn't say. Well, actually, the language it says if a child is removed from the parent's custody at any time, the court must permit the child's parent to have regular and frequent parenting time. It even includes under those circumstances. Yeah, you're correct, Your Honor. Under those circumstances, if a petition is requesting termination of parents' rights, then it's discretionary with the court. And then if you feel it's appropriate to have parenting time, then you have to look at what safeguards need to be put in place at that point in time.
Okay, so Mr. Brown, when we were off the record, you had indicated that provided proper safeguards in place, you as LGAL would not be opposed to supervised parenting time for Mr. Bradshaw. Is that still the case?
Yes, as long as DHHS can monitor and be in control of the situation, I don't think there's any harm at this point.
All right, so what we didn't have during the time that we were off the record with the attorneys was input from any of the DHS workers. So Michelle or Ms. Wiedner, either of you want to weigh in on Mr. Bradshaw's request for parenting time supervised by the agency? Well, it sounds like they're not. So,
Michelle, did you want to comment on that?
Well, I just wanted to say, Your Honor, that aside from the investigation and what we had already addressed, I don't have anything new to add.
Thank you. And Ms. Wiedner, I'm sorry, is it Wiedner or Widener?
It's Widener. And along with Emily, I don't have anything new to add either.
All right. Based upon that, I'm going to grant Mr. Bradshaw supervised parenting time with all of his children supervised by DHHS only.
Thank you.
Thank you, Your Honor.
And anything else the court needs to address today?
Not at this
No,
time.
Your Honor.
Oh, Your Honor.
All right, thank you. So we'll see you back here to continue the pretrial on the date and time that Shannon gave you. And I'll make sure all this other stuff is in my order. Thank you.
Thank you, Judge.
Okay, let's see. I think next up was Nefer. Let me see who I need to bring in for this. Have a good day, Mr. Bradshaw. Okay.
Your Honor, when the court is ready, I do have some names
I don't-
from,
Yeah, go ahead. I didn't see Nefer on the list. I was just looking really quick.
oh, it should be Sharon Ernst if she's there. And let me see the other one. Madison Bowen. And then placement would also like to be added in if possible. They have trouble with watching on YouTube.
Problem. But I need a name.
Yep. Margaret Fretwell is one of them. Holly Wilkes and Janet Sanford.
I do not see any of those names. Give me the three names again.
Margaret Fretwell, Holly Wilkes, and Janet Sanford.
I'm sorry, none of them are present in the waiting room.
Okay.
Okay.
Thank you for looking.
I think we've got everyone here now in the Nefer matter. Callie Tucker for the petitioner. Ms. McCluskey is LGAL. Who represents the parents?
Timothy Williams, Your Honor, on behalf of mother.
Michael Kelly on behalf of the father.
Yeah, let me look for parents now. Thanks for reminding me.
Your Honor, Mike, if he's there, his number would start with a 727 area code.
I've already identified all the people who had called in. Let me scroll through again and make sure, but I did not see.
My client should be trying to get on her, the 517-527.
I do not see Daniel Nefer anywhere, and I do not see. Oh, wait a minute. I think I see an Everett. Yes, Shanna Everett's present, so we'll get her in. But I do not see Mr. Nefer logged in, and I have everyone else in the waiting room is identified. Okay, so Shannon, we now have the mother present, Shanna Everett. Ms. Everett, can you hear me?
Yes, I can. Can you hear me?
I can.
Okay.
This was previously adjourned in order to provide an opportunity for psychological evaluations. Understand that that's probably unlikely for Dad, who's apparently in Florida. But has a psych eval been performed for Ms. Everett?
Your Honor, it did occur on January 19th. I have not received that report back. Ms. Louder indicates it should be finished and sent to me any day now.
All right, well, let's put this one off a week then. Hopefully within the next week, we will have that, and then we'll be able to determine where to go from there. But I lost Shannon. Oh, there she is. Shannon, put this over 1 week, please. We're waiting on this. The psych eval's been completed, but the report hasn't been issued. Adjourn the pretrial 1 week, and then once we have the psych eval, in a week, we'll decide when to schedule the trial. Does that make sense for everyone?
Yes.
Yes, Your Honor.
Yes,
Okay, we'll see you next week at 8:30. Thank you.
thank you.
Anything else to address?
No,
Okay,
Your Honor.
very good. Thank you.
Miss
Thank you.
Carol, Miss Carol, could you text me, please?
Okay, and let's see, the last of our pre-trials, neglect pre-trials, I should say. Hayden Riddle. So let's see. San Filippo, I saw her out there. Let me get her in. And let's see, what do we got for parents? Well, I'm not seeing your client, Ms. McCluskey. And Mr. Kelly. I'm not seeing your client.
He had indicated yesterday they were waiting on a ride to be moved to Lansing or another place within Michigan. If the court would want, you could try the number on the petition. I had success in actually reaching him through that number.
All right, I'll give that a try.
Beth Squire is also waiting in the lobby as well to join.
Oh, okay. She wasn't on my list. Let me get her in. This must be her. It says Beth. Yes. Okay, let me scroll through one more time. Make sure someone new hasn't logged in. No, neither parent is logged in. I'm going to try their telephones as listed on the petition. We'll try Mr. Riddle first.
Sorry I missed your call. You have reached William Riddle. Please leave your name, number, brief message. Thank you. God bless you.
Mr. Riddle, this is Judge LaFlamme. I was calling you for a court hearing regarding your son Hayden. We will proceed without you.
The Text Now subscriber you are trying to reach is not available. Please leave your message after the tone.
Ms. McMahon, this is Judge LaFlamme. I was trying to reach you for a court hearing regarding your son, Aiden. We will have to proceed without you. Okay, since neither parent is available, obviously we won't be able to take a plea this morning. We're scheduled for trial on March 2nd. I guess we'll just proceed at that time. March 2nd at 1 p.m. Where is Hayden placed currently?
Aiden is currently staying with his aunt, Katrina Crittenton, Your Honor.
And is that a placement by the agency or is that a placement, voluntary placement by mom?
Voluntary by mom.
All right. I guess we'll proceed on the 2nd. I'm sorry. Kelly Tucker for the petitioner. Ms. McCluskey represents mom. Mr. Kelly represents dad. Workers are Molly Sanfilippo. Need spelling?
S-A-N.
She's okay. And Beth Squire is also present. Anything else that needs to be addressed on the record?
Ken Hotchkiss, guardian ad litem.
Oh, I did miss someone important. Thank you. We'll see you next week.
Thank you.
Okay, let's see. What have I got now? I have got a Hillsdale County case that none of you folks are on, but I'm going to leave you in the courtroom. This is the matter of Jack and Nathaniel Shealy. See if I can figure out who all is on this one. Okay, Ms. Lamson, good morning. I've called the matter of Jack and Nathaniel Shealy for a dispositional review hearing, but you're going to have to help me identify who else should be present in the courtroom because without a county case, I don't have a docket that lists everybody's name. You're muted.
On court.
Ms. Lamson?
I'm sorry, Your Honor. The parties, the only party that I see here would be Jack Shealy and Terry Krebs. It looks like we're missing Roy Brandis and Jamie Wisniewski.
I saw Ms. Wisniewski, and I think Mr. Brandis was in earlier. He may have had to get off for another hearing. And hold on.
know-
Yes, I see Jamie Wisniewski. Let me get her present.
Oh, there she is.
Yeah, I'm pretty sure I saw Mr. Brandeis earlier. I'm not seeing him now. Do you happen to have a telephone number for him?
For Mr. Brandis,
Yes.
let me double check.
Is he on the neglect file?
He is.
Okay.
Yeah, the number I have for him is 517-437-3307.
And I'm scrolling through. Is there anyone else that you would expect to be present today?
I think Mr. Dunham is still on the case as well.
And I don't see Mr. Dunham. Who does Mr. Dunham represent?
I am not sure. It may still be one of the parents' attorneys.
I'm not showing him either. Let me try to get a hold of Mr. Brandeis right now. Oh, it didn't go through. Let me try again.
Roy Brandis Law Office.
Good morning. This is Judge LaFlamme in Jackson County, trying to reach Mr. Randis. We had a neglect proceeding this morning that he's appointed counsel on. Is he available?
He is not available. He's on another meeting through our court here because our notice said the hearing there was at 10:30.
There's actually two matters up this morning. There was a neglect hearing and there was also I think a pretrial in the DL case. I'll tell you, we'll just put this off until 10:30.
Okay, and I know Mr. Dunham is on the same hearing with Mr. Brandis right now, so.
Oh, okay.
So they're planning on being on at 10:30.
We'll just take care of everything then. That'll work. just
Okay.
fine.
Thank you.
Thank you.
Bye.
Bye. All right, we'll put this off until 10:30 and we'll do both the neglect and the DL. I think it's a pretrial at the same time.
Okay, so you'd like to hear them both at 10:30 then?
Yeah, I need the attorneys present, and since they're planning on being here at 10:30, let's just do everything then.
Okay, thank you. I'm going to be on another hearing with them, so I will let them know.
That's all right. I'll put you back in the waiting room. And you as well, Ms. Lamson. Okay, let's see. Got a couple post terms, or at least one post term to handle. Matter of Jordan Harbert. And I think I saw Jordan out there. And let's see, who's our workers here? Let's see, Joy Jennings. Maria Kleckner, sure I saw her. Mr. Brown, you are
Advocate.
Jordan's special advocate. And who's LGAL on this one? Mr. Kelly, isn't he?
Yes.
I am, Your Honor.
Okay, and Jordan is present. Good morning, Jordan.
Morning, Your Honor.
And who is that with Jordan?
Casey Nadler, Jordan's therapist at Havenwick.
You need a spelling, Shannon? Okay, so let's hear Mr. Kelly. Your perspective on how Jordan is doing.
I think he's doing okay. I spoke with him yesterday about the CTAC report and the recommendation of having contact with his mother. It sounds like it would be through correspondence because where she's at, the phone calls, there'd be an issue as to who's going to be paying for the cost of those phone calls. The CTAC report kind of speaks for itself, Your Honor. It confirmed the suspicions I had. But I am supportive if Jordan would like to correspond with his mother in regards to what the recommendations were through CTAC. I would have no objection to that happening. If that's going to help him heal and process and get out of that program that he's in, I'm all for it. Thank you, Your Honor.
So I did read that report, and I also read the agency report that recommends against restoring such contact.
Right.
So, and I believe that was at the recommendation of Jordan's counselor in his current placement. Is that correct? So I guess I want to hear about this. Sorry, Mr. Kelly, go ahead.
Your Honor, just quickly, we were supposed to be having a meeting with I believe it was Dr. Henry and some other individuals to discuss the findings of that CTAC assessment. I had indicated to the agency whether or not we should adjourn today's hearing to allow that information to come in. They felt it was going to take upwards of about a month to get all the same professionals on the same page in regards to that. So we can conclude today's hearing, Your Honor, but maybe set this for an early review to go over whatever the results are of that meeting.
Well, that's exactly what occurred to me when I read the conflicting information is that professionals need to talk and find out why there's some differing recommendations here. Does anyone know if Jordan's mother is even permitted to have any contact with him? Is there anything about her sentence that prohibits contact?
I don't believe so. A letter has been drafted that I have that mother sent that was intercepted. It was never, I believe, formally presented to Jordan. I don't know if the word intercept, but it wouldn't give it to Jordan. I read it. It was not perfect, but mother was heartfelt in her letter. She did minimize some of her conduct. But all in all, I didn't think there was anything wrong with it. It's my perception that the agency thought something was inherently wrong with it. A mother did ramble on at some points, but I thought overall it was a good letter. So yes, she has written letters, but it was refused to give to Jordan.
Your Honor, I think Joy and I were under the impression that I'm not sure if there's a no contact order in terms of mothers sentencing and things like that, but Joy and I were under the understanding that this court had a no contact, something within the order that stated no contact between Jordan and mother.
Oh, I got you. And I don't know if I ever put something like that in place in the past. If I did, it was because somebody was asking for it.
Right. Due to the nature of her her incarceration and things like that. I believe this court put that in the order.
What I would expect to happen then is let's have the Dr. Henry and Jordan's therapist talk. And if they can resolve the issue and decide on what form, if any, contact should take place, I'm fine with it, whatever they agree on. But if they disagree, then it has to come back in front of me. And I'm going to need to hear from Dr. Henry. Just a report isn't going to be enough for me. I want to be able to explore exactly, what his thinking is. I highly respect Dr. Henry and the CTAC. They're an extremely valuable resource. But I also understand, that he spent a day with Jordan, and the therapist spends a whole lot more time with Jordan than that. And the two of them hopefully can get on the same page. But if they can't, then I don't want there to be any contact unless Jordan's therapist agrees as to when and how. And if she does not agree, and Dr. Henry isn't convinced by her, he still believes that the contact is a good idea, then I want it back in front of me. I will hear some testimony from both of them and arguments from counsel and decide what's in Jordan's best interest. With experts in disagreement right now, there's no way in the world I want to weigh into this and allow the contact to take place until I've got a better handle on it myself. Does that make sense to everyone?
Yes, Your Honor.
It does. And Your Honor, something that Joy and I were also talking about is exploring what types of services mom has received to see, has she gotten treatment for, her own therapeutic treatment for everything that has happened? Will that help with improving her appropriateness with him? Those are some other things that we wanted to explore as well.
If I may address that, another issue.
Sure, I'll give a chance. What I would certainly expect is that the communications be screened. And if there's anything inappropriate in what mom is saying, obviously Jordan shouldn't be exposed to that. That could just make matters worse, not better. Mom is in prison because she exercised some extremely poor judgment. And I would certainly want some confirmation that she understands what she did, and maybe more importantly, what she failed to do and the impact that it had on Jordan and his brother. Without some ownership on her part, I think she could definitely inflict more harm than do good. Again, I want to hear from the experts. I want them to have a chance to talk, and then if they can't resolve it, then I'll weigh into it. I'm sorry. Go ahead, Mr. Brown.
Judge, if you had read that letter that mom wrote to Jordan, that would clarify what you just asked, some recognition of what she did. That letter was not submitted in the report. And I don't know why, but that would have given you some insight into her mindset. Further, I really don't know why we're concerned about what therapy mom is getting and what services she's doing. Jordan's 16 years old. By the time, we're not planning on placing Jordan with mom. Her rights are terminated. So I don't even know why we're going down that road. he's going to be of the age of majority before you know it. And he's going to do exactly what he wants to do. So I don't know why we're wasting time. If she does get help, great. But going down that rabbit hole, I think is of no significance. Further, one thing I also would like the therapist to discuss in the report after their few-hour meeting with the grandparents, because they did not show overt physical contact with Jordan because of COVID. They're listed as problematic for placement of Jordan. No one else is going to adopt Jordan. The grandparents are good people, no criminal record, loving, caring. They've been with Jordan throughout this entire situation. I just hit the floor when, and if they had have went up and hugged him, that would have been considered inappropriate because of the CDC guidelines. And so they're in a no-win situation. They're good people. Maybe they didn't do everything correctly, but to single them out as problematic, I think it's disheartening for Jordan and this whole case. He's 16 years old, or very shortly. Thank you.
Well, and let me set your mind at ease and Jordan's mind at ease. My hesitation at placement of Jordan with his grandparents is not because of any sense that they are unfit. It's because Jordan's not ready for it. Okay, so let's do this. I'm gonna schedule our next review hearing in 3 months, but if the meeting with Dr. Henry doesn't result in a common plan that Jordan's therapist can support with respect to resumption and restrictions on and format, et cetera, of his resuming contact with his mother, get a hold of Shannon, ask for an early review hearing. I'll get it scheduled right away. But at that hearing, I definitely am going to want to hear directly from Dr. Henry and from the therapist. And then once they both make their presentation and I've heard from the attorneys, then I will decide at that point what's going to happen.
And in the report, Henry just signed off on the report. I think his involvement in this report was minimal. My take is that his underlings did most of the report. So what knowledge he's getting is secondhand from whoever he works with. So I would like to know who these people are that actually did the report, their qualifications, what their background is. We know what Dr. Henry's is, but just to sign off on somebody else's work without having active participation, I know he trusts his colleagues, but
your point is well taken, Mr. Brown. If all Dr. Henry did was countersign a report that another professional at his agency authored and recommended, obviously that's the person we want to hear from.
Right.
But my understanding in the past is that Dr. Henry has a very hands-on approach to people who come through the CTAC versus just letting people do their own thing. But again, whoever it is, whether it's Dr. Henry, whether it's somebody that works for Dr. Henry, that's who I want to hear from.
Thank you.
Your Honor, may we
Yes.
request that we have discretion for supervised contact between Jordan and his mother for if we do come to a common plan between providers, that we have that discretion, and specifically would most likely begin with letters that would come through the agency and to the therapist to talk with Jordan. And that is, of course, with the provider's acknowledgement.
Yeah, absolutely. That was my intent.
Okay.
If the professionals can agree, absolutely, you have discretion to do what the professionals are recommending. You won't need to come back to me for an order if there's agreement on that plan. It's only if there's disagreement that it needs to come back in front of me, and I'll have to hear from everybody involved, whoever it is, and make a decision then.
Thank you.
Thank you, Judge.
Okay, that'll all be included in my order. We'll set our next review hearing for May 18th at 8:45. And again, obviously subject to an early review if that becomes necessary. Thank you. Jordan.
Thank you, Your Honor.
Good to see you. Is there anything you'd like to say? We're here talking about you like you're not in the room, and obviously you are in the room. So I certainly want to give you a chance to say something.
No, I don't have anything to say, Your Honor.
All right. Thank you. Good to see you. Wish
Me
you
too.
well.
Thank you.
Thank you. Okay, looks like we're ready for Axel Lovett. Let me, I know there's a lot of people here for this one. So Mr. Lovett and Ms. Russo, get them in. We have Ms. Nesberg from the tribe.
We're in court. My dad just texted, still waiting to get in. Oh, my dad, he just texted me.
Yes.
Hello.
Yes. Good morning. I'm going to mute your phone until we need to hear from you. All right, and I did see Mr. Kevin Lovett. Let me get him in.
We should have Madison Banks.
Okay. Yeah, let's see. I saw Sherry Hunt on a report. You expecting her? Let's see her.
That's possible. She probably took over the case.
And let's see. Okay, we are on the record in the matter of Axel Lovett. Ms. Russo and Mr. Keegan Lovett are present. Placement, Mr. Kevin Lovett is present. Callie Tucker for the agency. Mr. Brown is LGAL. Mr. Hotchkiss represents Mom. Ms. McCluskey represents Mr. Lovett. I think that's everybody. Also, Ms. Heidi Nesberg is here from the Sioux Tribe and Madison Banks for the agency. Let me ask, are we expecting anyone else for this hearing? There's still a lot of people sitting out in the waiting room.
I don't know of anybody else on this case.
All right, I wouldn't think so, but I just want to make sure. I didn't want to leave anybody out. Okay, so when last we met, we were interested in knowing the tribe's position on a goal change. And we're informed, if I remember correctly, that the tribe wouldn't make a decision on a goal change unless and until a petition for termination was filed. I have a termination petition. Has everyone else received a copy of it?
Yes.
Yes, Your Honor.
Yes, Your Honor.
All right. And Ms. Nesberg, what is the tribe's position on a goal change?
The tribe did meet on February 3rd, 2021. They reviewed the petition. They support the department's recommendation for termination of both parents' parental rights.
And Ms. Tucker, that is indeed the petition that the agency would like to proceed on.
Yes, Your Honor. Thank you.
Let's see. Mr. Brown, are you in support of the goal change?
Absolutely.
Mr. Hotchkiss?
Your Honor, it's my understanding my client is going to voluntarily release her parental rights. I relayed that information to Mr. Way, who was going to see if he could get that paperwork drafted and to me so that I could get her signature, go over it with her and so forth.
Ms. McCluskey?
Your Honor, that conversation with my client yesterday, that is also my understanding, is the parents are intending to release their rights so that Axel can be adopted by the parental grandparents. Thank you.
Okay, so we need to set a date and time for that to happen. So what we would need is to make sure that the release paperwork is prepared in advance so it can be signed by both parents and then returned to the court. And then I will do a non-public hearing to receive that release. Would it make sense for us to set that in 2 weeks? You think that'll give sufficient time for all the paperwork to get signed and returned to the court so I can proceed with a release hearing?
I believe so, Your Honor.
I would believe so as well, Your Honor.
All right, so is that something that Tara Lynn would be doing, or Ms. Tucker, will you be preparing the release paperwork?
I know Mr. Way previously sent Ms. Banks an email containing all of the paperwork that needs to be filled out. I don't know if Ms. Banks has begun filling that out or what, but I will certainly get with her and Ms. Brown to ensure that it's done prior to the next court hearing.
All right, well, let's set that for 2 weeks then. Shannon, how does our morning look?
March 9th.
We'll set that for March 9th at 9:15. Obviously, I will need both parents to be present via Zoom. That will be a non-public hearing. In the meantime, I am going to set this matter for a review hearing, just in the event things go south on us. That'll be May 11th at 8:45.
Actually,
If
things go south, wouldn't we set it for a termination hearing?
yeah, but I still have to have a dispositional review hearing on the record.
Okay, thank you.
Otherwise we lose track of those things, Ivan, and then I get in trouble
Okay,
for not doing things timely. But you're absolutely right. There would, if we don't do a release, then I'll have to schedule a termination hearing. Okay, anything else that court needs to address today?
No, Your Honor.
Your Honor,
Yes, Ms. Nesberg.
even though the parents are planning to release their parental rights, the expert witness testimony still needs to be given as far as active efforts, risk of harm. So at that hearing, I'll also need to give that testimony.
Is that testimony I could receive today?
If you want to, I can do that.
If you have someone ready, absolutely. Let's do it. And then I'm not sure that the context of a release hearing is the best place for me to be making those kind of findings because that's a non-public hearing. So do you have an expert available today?
That's me.
Oh, okay. Ms. Nesberg, would you raise your right hand, please?
Yes.
You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your full name, please.
Heidi Nesberg.
And Ms. Nesberg, what is your relationship to the, I'm sorry, give me the full name of the tribe first.
The Sault Ste. Marie tribe of Chippewa Indians.
All right, I'll refer to them as the tribe. What is your relationship to the tribe?
I'm a caseworker for the tribe.
Are you familiar with the child rearing practices of the tribe?
I am.
Are you prepared today to offer testimony with respect to active efforts that have been undertaken on behalf of the parents for the benefit of the children?
Yes.
What are those active efforts?
Your Honor, the department has had a case open for almost 1.5 years. They have provided a case plan to the parents, including substance abuse services, mental health services, visitation. Substance abuse and mental health continue to be the cause of concern in this case. Neither have concerns have been addressed by either parent yet today. Those would be the majority of the active efforts that were made. The parents just have not engaged in services whatsoever.
Looking for the language in my order. Give me just a moment. And do you believe that those active efforts to provide remedial services and rehabilitative programs designed to prevent the breakup of the Indian family, first of all, have been fully exhausted?
Yes, it's, I believe through discussion with the caseworker that there are no other services that could be provided. The services that have been provided are typical in a case. Again, the parents just not have engaged in those services, unfortunately, and those active efforts have been unsuccessful for reunification.
Counsel, any questions for Ms. Nesberg?
No, Your Honor. Thank you.
No, Your Honor.
No, Your Honor.
All right, I do find for the record that active efforts have indeed been made to provide remedial services and rehabilitative programs to prevent the breakup of the Indian family. Those efforts have not been successful. We'll see you back here in 2 weeks, hopefully.
Can I just say a couple more things on the record, Your Honor? I'm sorry.
I'm sorry, yes, please.
Okay. I also believe that there is a risk of harm if the child was returned to either parent for reunification services. The Sioux Tribe has met and is also in support with the department that termination of parental rights is in the child's best interest, along with myself.
Thank you. So the court will provide in the order that all efforts for reunification shall cease. The matter will be set for a release hearing as previously indicated. If in the event either parent changes their mind or the court finds the release insufficient, at that point I will set a date and time for a termination hearing. Okay, anything else the court needs to address today?
No,
No, Your Honor.
Thank you very much. Have a good day. Thank you, Ms. Nesberg. Okay, let's see. Looks like next up is.
When do we get a chance to talk?
Mr. Lovett, it's Rebecca, your attorney. You and I did talk about that yesterday. And it would not be today.
What is getting saying is horrible, and it's not true. I'm the one that did in the very beginning of this, went to treatment and completed, and I am in pathways right now. And I'm done with being talked like I'm some horrible man that is going to hurt my child.
Well, hold on a minute, Mr. Love.
I can't sit back and take it, and I won't.
So are you not intending to release your parental rights?
No, I am, but I'm just, what is being said about me, I am beyond upset, and how I have been treated through this whole thing is wrong. When this first happened, I wasn't even on the case. I voluntarily took drug tests and passed them. Veronica took her drug test and failed them. When I fell off the wagon, I told CPS, hey, look, I know I'm not part of this, but I'm going to treatment. I went to treatment. Some accusations were made that were never looked into, never investigated, taken for face value from someone that's already had termination of rights and failed drug tests when I didn't. And then they just took my son from me. And that did spin me out. And I did do drugs, and I'm sorry for that. But I'm not this person that they are making me out to be, and I am very upset about it.
So, Mr. Lovett, normally the sorts of things that you're telling me right now are things that I would hear at a termination hearing. Agency presents its evidence, you get a chance to respond to that evidence and question.
I'm not trying to be rude or anything to the courts. I'm just.
You wanted a chance to get this off your chest. I've given you.
Yeah, I just, you know, this has not been easy, you know, and I'm 38 years in the making of a drug addict, but I never harmed my kids. And it doesn't happen overnight. And it doesn't even happen in a year of getting right. And it took me a while, but I'm trying my ass off, my butt, sorry. And I did go to treatment in the very beginning of this, and I completed, and I did parenting classes there. And I tried to get out of Jackson to get my life better, and things got worse up here. Veronica was having a real hard time with her mental health, and she was having audio hallucinations and was making these horrible accusations, but because she literally thought she was hearing these things, she just spent 16 days in the hospital, and she's on medication, and she now knows, like, she's like, you know, she's just been so apologetic, like, I'm so sorry, and I'm like, it's okay, you're getting better, like, but you know, these people have heard things that are just not true, and they're going off of it. And it's like, it just sucks, because I just feel like, what if, you know, I haven't been the perfect parent as far as showing up. It's just been hard. I just don't want to be looked at like I'm just some scumbag that doesn't care about his kids. Like, that I've done these horrible things that I haven't.
So, Mr. Lovett, I hear you. I do appreciate what you're telling me. I understand how strong addictions can be, and how even with the best intentions, that it's a struggle, and I get that. I don't believe you're an evil person. You're a person who struggles with addictions. And what your child needs is to be brought up in an environment where those problems don't exist. And that's the
And I
goal of this
understand that, I really do.
At the end of the day, what I'm concerned with most is your child's, what's best for your child.
I know.
And I know it's best for a child if he or she can be raised in a loving home with healthy parents.
Yeah.
And I get that. I I don't think you're an evil person. I mean, that's not in, I hope, and we'll get a chance to talk about this a little bit more when we do the release. I'll give you a chance to get off your chest, anything you want to get off your chest. I do hear you.
Thank
and
you.
I am sympathetic. I know
I
if you
mean,
could do it over again, you'd choose to do it differently. I get that.
Absolutely, I would.
And I truly, truly hope that as bad as this whole experience has been, that you don't give up on recovery.
No, and I'm never going to. I'm doing really well right now. I finally got the pathways. I knew I had to do it, and I just want to do the reason that we want to do the release of rights is because we don't want to be cut out of his life. We still want to be there when we can.
All right. So I just wanted to make sure you've been heard. We'll see you in 2 weeks.
All right.
And if there's more you want to say, then yeah, you'll be given the chance.
Thank you, Your Honor. Thank you for listening to me. I was just like, man, I have to say something.
You're welcome, sir. I wish you well.
Thank you so much.
Okay, I think we are now ready for Cameron Bliss. And I'm pretty sure there's Ms. Ostrander. And what else we got? Hold on. Looks like Deborah Hines. There she is. Let's see if I got any parents out there. There's David Burnett. Let me get him in. Oops. I don't know what I just did. Oh, I see. Looks like Ms. Denke. And then let's see what else we got. I think that might be everyone. Anyone else for the agency besides Ms. Hines?
So, Your Honor.
Okay, so this is a matter of Cameron Bliss. Shannon stepped away, so I'll worry about identifying people when she gets back. How's that? Let's see, Mr. Kelly is LGAL. Mr. Kelly, how's Cameron doing?
Your Honor, Your Honor, each time I had attempted to call the phone number I have for placement, it kept giving a busy signal. So I was unable to get through to contact and speak with placement or Cameron. I have reviewed the court report to say it's not encouraging is probably an understatement. The psychological evaluation findings are concerning. Considering where we're at in the proceedings, it's not exactly encouraging the progress we're making or the direction we're headed. So I would like to see some improvement, especially in regards to therapy for Mr. Barnett, which it seems like it's going to take quite a bit for that to change directions. Otherwise, I reviewed the report. I have no further objection to the recommendations.
So, Ms. Hines, Dr. Louder doesn't have much hope for Mr. Barnett ever being a custodial parent for his child. Does that in any way impact your recommendations to the court?
At this time, Your Honor, because of the conflicting reports from Cameron's therapist, what she feels is in his best interest and Dr. Louder's recommendations for Mr. Barnett, we're really wanting to complete the CTAC assessment for Cameron to get a better idea and maybe some additional recommendations where Dr. Louder didn't provide any recommendations, and see what that level of trauma is for Cameron and just see how they feel, and then get all the service providers together and communicate about that. It's difficult when we have conflicting opinions.
Well, and I gotta say, as I read the body of Dr. Louder's psych evaluation, I have trouble squaring her evaluation with her recommendations. I know that these psych evals involve a battery of tests and a report that gets generated by the testing protocol that identifies tendencies, etc. But there seems to be a disconnect there. And I guess ultimately I would have to hear directly from Dr. Louder as to how she ended up at the recommendations she ended up with in light of the other findings. And perhaps she can explain it. I just had trouble squaring that. Usually when I get a recommendation as strong as this one is, there are a lot of indications leading to that as a result of the objective. I guess it's not totally objective, but at least it's based on responses from hundreds of thousands of people to test results and this psychological profiling. I had trouble processing that. Ms. Denke?
Judge, I'm asking that the court order that Dr. Louder provide me with all the information she received to prepare the psychological evaluation, as well as all of the testing data that she has. I have serious concerns about the psychological evaluation as well, and perhaps we'll have someone else take a look at that testing data and the information that was provided. My client only completed the 10th grade, did do some special education classes as part of his schooling. So he struggles a little bit when it comes to test taking and that kind of thing. The interviews were all done over the phone. And he's reported to me that Dr. Louder was going very fast. He kept asking her to repeat things because he just doesn't process that fast. And she was getting frustrated with him. So he finally just quit asking her to clarify or repeat things and just did the best that he could. There is no doubt that Mr. Barnett is very suspicious of this process. Not surprisingly, his kids have been removed from his care, and he doesn't trust what's going on. And I don't think that's unusual. He also is a private person and is finding being involved in a process where his life is now expected to be on display in its most intimate details, very disturbing. Frankly, if someone asked me to fill in a blank and the intro was sex is, I freeze too. I don't know what you put down. Sex is what? And especially coming from someone who's been accused of sexually abusing his son in the context of a divorce situation. He said, I'm not going there. That's sex is private, sex is personal. I wish he just put sex is private, sex is personal. But the questions made him very, very uncomfortable, and he didn't handle them well. And I think partially because of the disconnect with the phone interview afterwards, there really wasn't a way for them to get past that and establish any kind of real rapport. Part of the report over and over says she doesn't have any indication that drugs or alcohol are a problem, but her testing says that people who answer these questions are probably hiding drugs and alcohol problems. And that appears over and over again, even though there's no data to support that other than her test results. There is she suggests that Cameron is doing well in his grandparents' care, and that's not true. He's really is struggling there. And I think that's where Cameron's therapist is really seeing that he does much better in his dad's care than with other people. So I would like the court to order that information to be disclosed to us so that we can get a second opinion with respect to that. My client is working very well with Cameron's therapist. He has engaged with his own therapist. There were some delays there. The therapist had a death in the family, and there were a couple appointments that the therapist didn't appear for, and they're off on the right track now. Dr. Lauder's report says my client's not willing to engage in therapy. He thought she was talking about yet another therapist in addition to what was being done. So I think he's committed to and understands the process. And I think that he and the therapist are communicating well together now that things are getting going. But we recognize that there's going to be a little bit of delay before that therapist can weigh in. There's also an in-home worker, Angela, that he's now engaging with and will be working well. And I think will work well with that person as well. I would point out that the report kind of connects Cameron's behaviors to time that he's spending with his dad. But Cameron ended up not being with his mother anymore because of sexually assaulting his younger brother there. And that was during a time period when my client was not having any contact at all with Cameron, and he was living with his mother. So this has been a long-standing issue. And part of the difficulty is that they hold it against people if you don't admit to what brought the child originally into care. Well, we didn't admit that there was any kind of sexual abuse perpetrated by my client. He's adamantly denied it, but ultimately decided that he would admit to an amended petition with respect to Cameron because he knew going forward with his other child that there would be ongoing battles with that mother. And that was a child he hadn't seen in an extended period of time. What we're asking the court to do is go ahead and continue to allow the parenting time. We still believe that parenting time is safe without supervision. And I appreciate Ms. Hines noting that there are very conflicting reports in terms of the people who are working with Mr. Barnett. The other thing is he is moving currently. And I know Ms. Hines wants to inspect his new home. He's just requesting that wait until he gets moved, gets unpacked, gets a chance to get things set up. He doesn't want to do anything wrong, and he's worried that, kind of the chaos of moving and getting things organized is going to be used against him. He recognizes that the plan is not for a return home in the next month or so. So the home inspection hopefully can wait a bit when we're not looking at returning him home there. Thank you, Judge.
So, Ms. Denke, one of your requests is that Dr. Lauder provide you with what she was provided with. I'm assuming Ms. Hines can provide you with exactly what was provided with Dr. Lauder. Well, her practice is she doesn't look at anything until she does the psych eval, and then she looks at it. But whatever she would have had about the case came from him or from Ms. Hines, or that's accurate, isn't it, Ms. Hines?
Yes, Your Honor. Yep. She provides a list of the material that she is requesting, and she states that she does the evaluation and then refers to the reports and petition that has been provided after the evaluation has been completed.
Well, it's certainly clear that from her report that part of her assessment is, well, I have this information and Mr. Barnett did not disclose that, and therefore that's concerning. Mr. Barnett assumed that she would have everything CPS had, so there were things he didn't talk about in his rush state with her. But that clearly has impacted the recommendations and conclusions that she reached. So I think it is important to have those, whether I get those from Ms. Hines or from Dr. Lauder, as long as I have everything.
And that was the only point. If you could, Ms. Hines, provide her with that list. I don't know. You probably already have everything that's on the list, Ms. Denke, but at least if you have the list, if you see something there that you don't have, you can ask for it. How's that?
Sure. And I certainly don't have the initial referral or anything like that. Any communication that would have happened between the agency and Dr. Lauder. And then it was the court ordering her to turn over her testing data so it can be reviewed?
Yes, I'll order that. That way you can have it independently checked.
Thank you, Judge.
So Shannon, to get you caught up here, we're on the Cameron Bliss matter. You got everybody's. Deborah Hines is the worker. Mr. Barnett is present. Ms. Ostrander is present. I think that's everybody. Okay. All right. Anyone else want to weigh in on this?
No, Your Honor.
All right, I think Ms. Denke's requests are appropriate. Ms. Hines, if you could please provide her with a list of whatever was given, as well as any communications from the agency to her. If there was anything other than documents, the referral, the specific referral, so she can see what Dr. Lauder was acting on. Sure. I'll order that Dr. Lauder provide the actual raw testing data so that Ms. Denke can get it evaluated by someone else. I'm not, at this point, inclined to follow Dr. Lauder's recommendations and gloomy outlook for Mr. Barnett without some better background. I do believe Cameron would benefit from a CTAC evaluation, and I'll definitely authorize that. I think continued supervised parenting time for Mr. Barnett is appropriate by the agency. Again, as I've indicated before, if Cameron makes sexual disclosures against his father, then at that point, I would expect the supervised parenting time to cease. I frankly don't expect him to do that. He hasn't done it yet. He's not likely to do it going forward. Clearly, this boy has been subjected to sexual abuse by someone. Kids don't act out the way he's acting out absent exposure to either sexually abused or sexually explicit material. I'm sure hoping that the CTAC can get to the bottom of that. But we'll see what that yields. I will set our next review hearing for May 11th at 8:45.
Judge, I'm sorry, I missed the date.
May 11th,
May 11th.
8:45.
And Judge, the agency has been allowing the placement and my client's fiance to do the supervision, I believe. I just want to clarify that the court is still permitting that.
Yes, by the agency or its designated.
Thank you, Judge.
Thank you, Your Honor.
Thank you.
We're done.
Weird.
We've got a full 25 minutes before 11 o'clock.
Okay. Morning, Peter. Fine, how are you? Okay, let's handle the Sheely matters now. I've got everyone here. Okay, let me see if looks like I've got audio connections with everyone. Mr. Brandis, is that you at the 427 number?
Correct, Your Honor.
All right. Okay, so I actually have a review hearing for Jack and Nathaniel Sheely in the neglect proceeding, and I've got, I believe, a pretrial in the DL proceeding.
Get it to go up.
I'm sorry, Mr. Dunham.
There it goes. Okay. Probably too loud now. All right.
Okay. All right, let's make sure we've got everybody down for the record. Jack Shealy is present with placement. Elizabeth Lamson.
Yes, Your Honor.
For the department. Jamie Wisniewski, do you need a spelling, Shannon? For the petitioner. And Mr. Dunham, I'm not sure your role here. My apologies.
I'm not sure either, but I have Mom, Mrs. Shealy, and haven't talked to her in about a year, I think. But yeah, I have Mrs. Shealy.
All right, Mr. Roderick Dunham represents the mother.
Yes.
And Mr. Brandis represents Mr.
The
Brandis?
GAL, sir.
All right, Mr. Brandis is LGAL. I don't know, maybe.
I do believe we should also have Mr. Smith, who I think was in the waiting room. It should say G. Scott Smith. He represents, I think, the father.
Oh, okay. I see G. Scott's iPad. That must be he. And we're trying to get an audio connection there. Mr. Smith, can you hear me?
I'm present, Your Honor.
All right, and you represent?
Robert Shealy, the father.
Okay, so let's do the neglect case first.
Your Honor.
Yes.
Excuse me, I'm sorry to interrupt, but this case is going to be transferred back to Hillsdale County DHHS workers after today's hearing. And I believe Maya Kavanaugh may be in the waiting room.
Oh, okay. I see Mr. Kavanaugh. Let me bring him in. Thank you. And anyone else speak up if you think I'm excluding someone.
I think
Try to get everybody.
I think Mr. Boak may be floating somewhere out in computer land as well.
All right, I see Nicholas Boak. I'll bring him in.
Thank you, sir.
I'm here as well, sir. This is Tasha. I'm Nathaniel Shealy's probation officer.
Oh, okay. So we're going to do the neglect hearing first, and then we'll.
Your
do the
Honor,
pretrial.
could you add Samantha Krebs too? She's my daughter and she's part of the family. She wants to attend.
Sure, I can let her in. She's also free to watch the YouTube proceeding if she wants, but I'll bring her in.
Okay.
And mute her.
Okay, thank you.
Okay. So, and I recognize all the other names that are out in the waiting room, and I'm reasonably certain they have nothing to do with either of these files. So, I'm going to write some things down here. I normally have something to refer to, but with these out-of-county cases, sometimes it's a little bit confusing to me, just because we don't have the official file and it's not in our filing system. So let me, Mr. Brandis, can you hear me?
I can, Your Honor.
You are LGAL in the neglect proceeding, correct?
Correct, Your Honor, and I have multiple roles with these two cases. I do represent, or I act as guardian ad litem for Nathaniel Shealy and also Jack Shealy. Both juveniles are also on juvenile probation, in addition to being a component of this neglect case. At this time, Nathaniel is placed at the Maurice Spear campus, and I have met with him, again, virtually over the last year, several times. It is the appropriate placement. He is not always very happy there. There was some prospect of him being placed with a foster family. Unfortunately, that foster family was the same one that Jack Shealy was placed with when there was an alleged incident that occurred that resulted in criminal charges against Jack Shealy. So that placement was no longer a possibility or an option. Nathaniel continues to make some progress at Maurice Spear campus. I'm familiar with their program. I understand that there are challenges from time to time with Nathaniel. Behaviorally, sometimes he acts out and it results in him being knocked back a few steps, and then he will kind of smooth out his behavior and respond appropriately, and then makes some additional progress until there's another incident. Overall, however, he is certainly in a much better place now than he was at the last review hearing, which took place 3 months ago. So I believe that placement for the near future will continue to be at Maurice Spear for Nathaniel Shealy. With regard to Jack Shealy has been placed with his grandmother, Terry Krebs, who I believe is also participating in this hearing. I have heard of no incidents regarding Jack in the home of his grandmother over the last 3 months. I have spoken with Jack a couple of occasions, more in connection with his criminal charge, basically what's going to happen to me, as opposed to any concerns or problems that he has in staying with his grandmother. That's where he wants to be, and for all appearances, it does look like that's the appropriate place. He is safe, he's not at risk, and he is at this time not really causing any trouble. As far as long-term, regarding this case, I don't know. I mean, it continues to be a very big challenge to find a place for Nathaniel, and frankly, until these criminal charges can be resolved, we're not going to be able to make any long-term decisions regarding Jack. But at this time, I do believe that both placements are appropriate in the best interests of Nathaniel and for Jack Shealy. That's all I have, Your Honor. Thank you.
So, Mr. Brandis, I did note that the court report indicates that the goal is guardianship. And guardianship obviously is not going to be able to be finalized as long as the criminal matters remain pending and unresolved. Is that accurate?
I would agree with that, Your Honor. And again, there is the additional variable of which child we're talking about. I mean, I agree with you with regard to Jack. Obviously, these criminal charges have to be resolved in some fashion before any long-term goal can be achieved. But there also has been some talk of Nathaniel, upon his release, also going with grandmother, Terry Krebs. And I know the department had some concerns about that, whether or not that was safe or appropriate for Nathaniel. But I agree with you. Neither one of those things could happen or should happen before the criminal charges involving Jack Shealy are resolved.
But in light of all of those, you still believe that guardianship is the appropriate goal for both minors?
I believe that that's the appropriate stated goal, correct.
All right. Thank you very much. So Ms. Lamson and or Mr. Kavanaugh, do either of you have anything to add to the report or have any updates for the court?
Your Honor, I would just like to add that we are diligently searching for placement for Nathaniel at this time. We had a meeting with the permanency resource managers last week and also our BSC director, and we actually may start looking at more of a step down unit for Nathaniel to transition him back into the community as opposed to straight into a foster home. We feel that that would best suit his needs because he still struggles with his impulsiveness. He broke his hand last month after a hearing that he didn't think went the way he wanted it to, even though he was just really confused about what had actually happened during the hearing, and that, you know, he's had to have surgery on his hand and will have to have surgery again. And that's why he's not present today, is because he's attending an an appointment with a specialist. So I am putting together the referral packet in order to do that, to help find Nate placement. Jack is doing pretty well overall. He was really struggling with his grades. He was able to bring them all back up and pass all of his classes last semester. So I'm really happy with him on that. And otherwise, that's pretty much where we're at this time.
And Ms.
If I could
Kavanaugh,
interrupt,
Ms.
could I interrupt a
Kavanaugh,
minute?
You can wait. Ms. Kavanaugh, my apologies. I think I called you Mr. Kavanaugh. I can see obviously that was an incorrect title. What's your first name?
My first name is Maya.
Maya, and you're going to be taking over the neglect case once you get the referral from Runaway County?
That is correct, Your Honor. And I have nothing else to add today.
All right, thank you. All right, so I'm sorry, ma'am. I don't have your name on the screen, so, and I'm scrambling looking for it. You are
Terry.
Jack's
It's Terry Krebs.
grandmother.
I'm Terry Krebs. I'm Jack's and Nate's grandmother. And Andrea Bricker is in the waiting room waiting to come into court. If you could allow her, that's what I wanted to interrupt for.
Oh, sure, no problem.
Your Honor.
Who is she?
She's Jack's therapist. She's with Integro.
Sure. I'll let her in. Somebody
I
else is trying to get my attention.
Yep, I
Good
apologize, Your
news.
Honor. Marcia Hammond sent me an email and said she's also waiting in the waiting room.
Ah, I see Marcia. I didn't know she was on that case. Good morning, Marcia. Sorry for the slight. I didn't realize you were on this case. Hello? Looks like we've got a connection problem. Ah, that's why. Sorry, Marcia. Ms. Hammond just walked into the court. I just learned that that's why you were in the waiting room. So Ms. Hammond is present. No wonder she wasn't answering me. All right, I haven't moved on to the DL case yet. I wanted to finish up the NA case first. So I guess we really didn't exclude you too badly yet, since I haven't called the DL case yet. Anyone else would like to weigh in on the report and the recommendations in the NA case?
Your Honor, if I may.
Go ahead.
My name is Tasha Berger. I'm Nathaniel Shealy's probation officer. Nate was placed in Maurice Spears Detention Center on July 3rd of 2019, and he was transferred to open unit in September 12th of 2019. He has entire time working on his behavior. He is currently on phase 4, which is the highest level you can be on at Maurice Spears. That is not given, that is earned. He has earned that. So he is ready to be released at any moment. This court financially has been obligated to, from the juvenile delinquent side, paid for everything for Nate's stay. And at this point, I see that it is fit for him to leave. The Maurice Spears staff believes he's fit to leave. He would be here today to talk to you about that, as well as his therapist, but he is having a screw removed from his wrist today. That is one of 2 surgeries he will have to have, and physical therapy twice a week. Nate just recently started receiving medical collection bills at Maurice Spears. They are not being covered financially by Medicaid, I guess. And so one of them, which was a $65 bill, Maurice Spears campus took out of his account where he has his own money he has earned there. I've asked them not to do that anymore because that's his money that he's earned, and medical bills should not be paid for by the juvenile. So at this point, he has another pending one that's $140.84 for a knee brace that is apparently not covered by his insurance, or maybe not. The insurance is not being covered right now. He's doing very well compared to where he has been and where he was. And I know he still has impulsiveness and issues controlling his temper. But for the most part, as right now, I believe he's in the best place he's going to be mentally to get out of Maurice Spears. So at this point, I'm going to recommend on my juvenile delinquent docket that he be released from Maurice Spears.
I do not have his DL case up today. I don't have a file on his DL case. I don't even have his DL case. I think that's in Hillsdale, isn't it?
Yes,
It
sir.
is.
And bringing that up is just, I want to make sure that DHS understands that we no longer will be housing him at Maurice Spears campus. I've talked to Liz Lamson numerous times, so I've asked her to find placement numerous times, but we're at the point now where he is ready to get out any minute. And so I just wanted to make sure you were aware for his placement needs, they've already been met. He's successfully ready to be released.
So in the neglect case, should I be ordering that he be placed with DHHS?
I can't tell you what to do in your job, sir, but I would, at this point, he's successfully completed. And normally at that point, I would release from Maurice Spears. I haven't done that because I don't want to leave the child homeless. We have to have a place for him to be.
Right. Well, I think at the point that he's released to DHHS, DHHS becomes responsible for his care. I can't order him released because I don't preside over the DL case. What I think I can order, unless you guys want to convince me otherwise, is that upon his release from the DL case, that he is to be placed immediately with DHHS. I can include that in my order today.
Sir, that would on my end, because it will be very soon. And I have no problem talking to Maya or Liz about that, but it will be very soon that he will be released. That would put a stipulation where we know who is to care for him at that point.
What's the docket number for his DL case?
18424249.
That's a lot of numbers. I'm looking at Jack's DL case, and it's only got 4 digits after the year. Anybody else have a different number for that? That just seems odd that they would have such vastly different number of digits in the file name.
Your Honor, I
Oh, is
have
that one?
I have the last order up regarding Nate's DL case, and that is the same file number that I have.
Okay, I'll use that. The reason I questioned it is that it didn't look right. All right. I can certainly provide in my order today in the neglect case that upon his release from that DL case, that he be placed with DHHS for care and supervision. Unless there's an objection to that.
I don't think that's an issue, Your Honor. And I spoke with Ms. Lamson yesterday about the situation for Nate, and she is in the process of trying to find a placement for him. We're looking for a situation that some kind of maybe a group home or a step down facility or something. And they're also in the process of looking for a foster placement. We don't believe that it would be appropriate based on prior issues. And I think Ms. Berger agrees that he go to Ms. Krepp's residence. We don't believe that's an appropriate placement for him. So we're actively seeking another place where he can go because we are aware he's ready to leave Maurice Spears.
As long as these charges are pending against Jack, there's no way in the world that the two of them should be placed together. Okay, I think I'm ready to conclude the NA case. I will set this for our next review hearing. May 18th at 8:45. That will be by Zoom again. If things ever open up so that I can actually go to Hillsdale, I can conduct a hearing down there. But at least in the foreseeable future, that doesn't seem practical. And you can Zoom into Jackson just as easily as you can Zoom into Hillsdale. So at least for the time being, I will at least be sitting in Jackson County for these hearings. So give me just a moment to write something on my order. Okay, thank you. So now I'm going to move on to Jack's DL case 23505 DL. I think I've got everyone here now. I'm not sure everybody that's here is on that file, but if you don't want to stick around, you're welcome to excuse yourselves from the proceeding. Ms. Hammond, you're now actively involved in this case? All right. What are we looking at here? We're looking at a bench trial, a jury trial? All I've got on this case right now is this. Oh, okay. All right, so Mr. Brandis, there is a jury demand in this file?
There is not, Your Honor. This was requested as a bench trial. The court may recall the last time we addressed this issue at a previous pretrial conference or status conference. We did not believe, the prosecutor and myself, we did not believe that this case was able to be resolved by plea bargain at this time. Mr. Shealy, I've talked with him on a couple of occasions since that last pretrial conference. So he does request a trial of this matter. Due to COVID, there are some logistical issues, and at that time I had requested that the trial be in person and not via Zoom or virtually. The court acknowledged my request. The other issue was whether or not you, Your Honor, would visit Hillsdale in order to conduct this trial. And obviously at this time, the Hillsdale courthouse is closed to in-person trials and hearings. So that creates a logistical problem until the COVID issue has been cleared up. So I guess it's probably appropriate to simply adjourn this matter and see at that time whether or not we are capable of scheduling the matter for trial.
Your Honor.
Yes.
Sorry. I did receive an email from our district court late last week indicating that our courts had been approved to move to phase 2. And so at least our district court is doing some in-person hearings. They just resumed in-person preliminary examinations and bench trials. So I don't know what Judge Bianchi's position is as it regards to her courtroom. She has been indisposed due to a family emergency the last couple of days. So we haven't been able to touch base about that and what that's going to mean for the probate court. But it's my understanding our courthouse has been approved to move to that phase 2. So they're not going to want like an influx of people for a jury trial, but perhaps for a bench trial, we could maybe get scheduling now that we are being approved for phase 2.
Well, let's do this, Ms. Wisniewski, since you're present down there. Let's put this over for a couple of weeks. Confirm that the courtroom is available down there for an in-person bench trial. And we'll have to find a date when the courtroom is not being occupied by anything else, so that I can arrange to be down there. I certainly, Mr. Jack Shealy, certainly entitled to an in-person trial. And that trial needs to be conducted in Hillsdale County, and I would be the one that would be presiding over it. Let's find out whether the parameters that are in place will be sufficient for me to conduct, given the number of witnesses, and maybe we can set a date at the next pretrial and make arrangements to move forward. Are there any outstanding discovery issues?
There are not, Your Honor.
Everybody knows who the witnesses are going to be?
I think it's pretty straightforward. I believe Mr. Brandis was provided with a copy of the police report. I don't know that we've exchanged official witness lists, but I think that they're fairly obvious from the report. There's nobody that should be surprising.
All right, so let's put this over. 2 weeks should be sufficient for us to try to coordinate a date when I can be down there and the courtroom is available. How long do you anticipate this trial? Is this something we'll be able to complete in a day?
I expect no more.
Say half a day, Your Honor, to be honest.
Yeah.
Oh, okay. All right, very good. Let's do that. We'll see you back here in 2 weeks. That puts us at March. What, Shannon? March 9th. Let's set it a little bit later. Let's set it at 11 so you guys aren't waiting around. I don't know how busy my docket is in 2 weeks, but
Mr. Brandis,
that'll be via Zoom.
do you have a trial scheduled that day as well? Or is it just me?
In the afternoon.
I have one from 9 to noon.
What's the one at 9 o'clock?
Hamilton?
I didn't have that written down.
Oh, well, surprise. Sorry.
Sounds like a bad time. Could we do it at 1 o'clock?
Yeah, if we started right at 1, we have a hearing at 1:30, but if we got right in at 1, we could be done in plenty of time.
No reason we shouldn't be able to do that. Shannon, set it for 1 on the 9th. Whoever sets, make sure that there's a slot on my schedule to do this at 1 o'clock. And we'll see you back here then.
Thank you, Your Honor.
Thank you all. Have a good day.
Thank you.
Okay, I just let everyone else in. I still got, let's see. Thank you, Marcia. Sorry for, I forget you. Nobody told me. All right, we have the educational neglect case for Aiden and Sophie Omac. Kelly Tucker for the petitioner. Doesn't look like we have a petitioner present. I know that Ms. Richardson was unable to attend today.
Lynn Williams present, Your Honor.
So I'm not sure who said that.
I did, Your
Who's
Honor.
Lynn Williams? Oh, okay, present with you.
Yes, is Caitlin Williams present from the ISD?
No, she's not.
Oh, okay.
And I haven't seen her at all this morning. Mr. Brown, you're LGAL on this file. Mr. Omac is present. I do have a report from Ms. Richardson. According to a report, Mr. Omac, you agreed that you would contact Da Vinci and try to get Aiden and Sophia switched back to in-person. Have you had any success in accomplishing that? Mr. Omac, can you hear me? I've got a screen that shows him present, but clearly he either stepped out of the room. I don't have an image. I just have his name across the screen. I don't think we've got a connection with him. Let me see if I've got a phone number.
The number you have reached, area code 517-296-1798, is not in service. Hello,
Hello?
who's this?
This is Judge LaFlamme. I'm trying to reach the parents of Aiden and Sophie Omac.
What was that, sir?
Judge LaFlamme.
I'm not a judge.
I am.
Oh, and who are you trying to reach?
I'm trying to reach Tina Flynn.
Oh, I'm not Tina Flynn. I have a new number, and Tina doesn't call Tina phone for the past 2 months now. And this is not Tina. This is Rose.
Sorry to bother you, ma'am. Have a good day. Okay, well, Mr. Omac's apparently not able to receive a call, and I'm not getting any connection with him, audio connection. I have recommendations, frankly, based on past performance. I don't see any likelihood that what Mr. Omac says he's going to do is actually going to happen. He has no control over his children. His children run him rather than him running the children. They do what they want. They don't go to school because they refuse to get up. They don't participate in online learning because they refuse to do it. And he doesn't make them do it. Callie, I don't know if you've had any conversations with Matt about this. In the past, we've talked about referring for prosecution through district court because we waste our time. I've spent so many hearings with the Omacs, with Mr. Omac and his children. Ms. Flynn rarely participates. And it's the same old story. Nothing changes. He's
Right.
not going to get his kids to school. He can't control them. Something more serious than an ed neglect petition needs to be filed.
So prior to this hearing, I had received just a brief update from Matt, and it just said that this has been basically what the court just said. This has been an ongoing issue, and that something needs to be done. According to Matt, our office did file a district court complaint last year, but then all he said was that COVID screwed that up. So I'm assuming whatever happened with that complaint, the judge took a look at it and said, well, with COVID, can you really expect parents to have their kids in school? And I'm assuming that's where that ended. I'm happy to communicate with Mr. Way again about that and see if our office does want to refile something more serious than just an ed neglect petition, but that's the only update I have at this time.
This is serious neglect. He can't get his children to get out of bed in the morning. We're not talking about a 16 and a 17-year-old. We're talking about a 10-year-old, and it looks like a 11-year-old. Well, wait a minute. No, that's not right. A 9-year-old and an 11-year-old. This is crazy. If he can't get his children to school, they ought to be with somebody else who can get them to school. This just doesn't work. You know, how is this not worthy of not an educational neglect petition, but a true neglect petition? And if he's not going to do what we tell him to do, these kids should be removed and placed with someone who can get them to school. And as I read this report, I mean, this is terrible. And it's consistent with what we've heard at all, heard before. We've heard all of this before. He told Ms. Richardson that when they were attending live, that he doesn't have a car, so he can't transport them to school. There is a bus that stops nearby, but the bus comes too early. He admits he gives in to them easily when they don't want to do something. He's been telling us that for months, for years. He says he doesn't like to be hard on his children because he feels bad about them being placed in foster care when they were younger. He tries to get them to do their work, but they don't listen. He doesn't know if they're even doing any work. He doesn't have the patience to teach them because of his own mental health diagnosis. Where's this going to end? And if I could simply put this out for 6 weeks, and I don't fault Ms. Richardson because she didn't have the history with this family. She's relatively new to the scene, but this is same old, same old. The education of these two children is being seriously neglected.
Right. I'm happy to have that discussion with both Mr. Way and my superiors again to see if they feel, and I'm assuming they will, refiling a petition in district court as it relates to dad's neglect is appropriate. I think the only reason that didn't go anywhere before is because of COVID and the delays and all that kind of stuff. So if the court wants to set this out, I'm happy to follow up with everyone this week. And if we decide to get something filed in district court, I'm happy to make sure that gets done.
So one of the bases for the court taking jurisdiction over a child in a neglect proceeding, as opposed to an educational neglect proceeding, is the parent or other person legally responsible for the care and maintenance of the child, when able to do so, neglected or refused to provide proper or necessary support, education for the children's health and welfare. Why don't we get more serious with this? Why don't we get DHS involved? Get them to file a petition. These kids are being seriously neglected. Handling this as an ed neglect case is a waste of everyone's time, and it's a disservice to these two children. If he can't do it, if their mother can't do it, they need to be in a placement that can get them to school. And I suspect there's probably a placement out there who can. You just need to be firm with children and make them do what they're supposed to do. If you're not going to be firm with them and you're going to let them run the show, that's what they're going to do. That's what these two children are doing.
They need to talk to you.
Your name is on. I know. I would like you at least to have that conversation with the folks at DHHS. I just don't want to start down this path again where we get nowhere. In the meantime, these kids are just being seriously neglected. If I had a good parent that I could put them with, that'd be easy. I've done that in an ed neglect case. I've removed placement from the parent who's not getting them to school, and I put them with the one who is. But I don't have that here. I got two parents who can't make these children toe the line. So the only thing left is placement out of the home.
Yes, Your Honor. And I understand the court's position, and I'm happy to have that conversation.
Okay, so I'm going to order what was recommended by Ms. Richardson. We'll just include it as written in the report. We'll set this out for 6 weeks. But in the meantime, I wouldn't wait 6 weeks. If you can get DHHS to get behind a petition, I will absolutely authorize placement of these children with somebody who can get them to school. This is too much.
Understood, Your Honor.
Mr. Brown, did you have anything, any comments you'd like to make on the record?
Nope, you said verbatim everything that I was going to say, so you saved a lot of time. Verbatim.
All right, so let me see. Shannon stepped away, so let me find that date will be. Let's see. Today's the Actually, I'm going to set it over to the 16th of March at 9:30. And we'll see where we are then.
That'll work, Your Honor. Thank you.
Make that 9 a.m. on the 16th. Okay, let's see. Looks like our last case today is Messiah McGuire. And let's see. Ms. Marcy Rowe is here.
Yes, I'm here.
Okay. Ms. Tucker for the petitioner, Mr. Kelly's LGAL. Ms. McCluskey represents Mom, Mr. Hodgkins represents Dad, and let's see, Samantha Wright's our worker. Mr. Kelly, how is Messiah doing?
I spoke with placement, Your Honor. Messiah is doing well. They have no concerns there. Essentially, what's in the report speaks for itself in relation to Messiah. I reviewed the report. I have no objection to the recommendations.
Ms. Wright, do you have anything to add to your report?
The only thing is that I recommended that Charles be in compliance with the sex offender registry status, but I spoke with a trooper and he is part of that law that was passed that he doesn't have to register anymore because his offense was before 2011. So that doesn't have to be in my recommendations anymore.
I'll remove that. Wait a minute. Oh, so this is actually disposition today. Okay, sorry. I was thinking it was a Ms. McCluskey or Mr. Hotchkiss, do either of you have any objections to the recommendations?
I do not have any objection, Your Honor, but we would like to be heard on placement when appropriate. The court, we did set this as a reminder. We set the disposition 2 weeks out so the agency could confirm my client's compliance with services and that we could address placement today. Thank you.
Nope, well, go ahead.
Thank you, Your Honor. So at this time, the Messiah is placed with relatives, but the relatives are in Bad Axe, Michigan, which is a 3.5-hour drive. So these parents are not able to see Messiah. I know the agency has tried some efforts to help with transportation, but the fact is I believe if it was bus transportation, they can only get to Bay City, which is still an hour, 20 minutes away from Bad Axe, and they have to secure a cab at that time. So it's an impossible burden on the parents, quite frankly. So in Messiah was just 1 in December. She's never been away from her mother. She's very young. So we're asking for a return home to my client. I think the agency, the only real concern, whether it's founded or not, that they have raised is that they don't believe my client will keep Mr. McGuire out of the home. That is absolutely not true. She will do anything and everything to get Messiah home. He has not been at the home. There's a reference to him doing laundry there at some point. It's an apartment complex, and my client reports that the laundry area is not in her apartment. So he was not at the apartment, but he was at the complex. And unfortunately, we see this. This is his home, and he's displaced, and he is kept out of the home. But there are certain, obviously, barriers to parents trying to navigate that system. My client has no CPS history. There is no domestic violence history other than the very recent events that led to this case being filed. My client engaged in services immediately. So she engaged in services in December, right after Messiah was removed, and our prelim was the beginning of January. Obviously, she's still not ordered to do services. She is engaged with recovery technology. I did speak to her case manager. She's been consistent on a weekly basis since December. Her case manager, Deborah Code, reports that she's very engaged and very motivated. She's actually looking for her own place because obviously Mr. McGuire, this is his legal residence too, where my client stays. She is actively looking for her own place so that it will be easier for the parents to stay separated. They're working on that. They're working on getting birth certificates. She was referred to therapy. She is doing consistent domestic violence therapy with, I believe it's, I'm blanking on that, but she is engaged in therapy for domestic violence, and she has been since right after removal. She engaged in parenting classes immediately after removal. In fact, on I think December 10th was her first. There's a reference to her being inconsistent with parenting classes. Absolutely not true. She attended December 10th, the 17th. There was a break for the holiday. The actual center wasn't offering services over the holiday until January 7th. She re-engaged immediately. And then there were 2 weeks where she did miss because of an abscessed tooth. And she was seen at the hospital for that. So there was a medical reason, and she re-engaged immediately after that. And last time I spoke to her, she had only one outstanding.
We have two. Sorry.
I believe, and she's set to complete those, but the challenge is recently the center went to in-person classes from virtual classes and only allows 10 participants. So there are some nuancing, but she's almost completed that. I do believe the psychological is scheduled, and she was immediately reaching out to me trying to get that done. So I hope the agency has done that as well. So as the court can see, the recommendations, she's been engaged in those, and if not completed them since December. The psychological evaluation will just need to be completed. But the fact is, there's no history, no CPS history. I think this is a completely unnecessary removal in the first place. Obviously, domestic violence is significant, but there were limited instances. There's not a history here. I know Mr. McGuire has a history with this couple, but it does not pertain to the child. And again, with the child being 3.5 hours away, it's just, these circumstances can't remain in this way. So the court did grant discretion to return home at adjudication. And I know the agency has likely confirmed what I just reported. Again, my client's been engaged since day one. There's no history, and this child is 3.5 hours away and is just over 1 year old. Thank you, Your Honor.
That's right.
Yeah, so I did get confirmation that she has 2 parenting classes left. She is working with recovery technology, and I know that she's working on getting a new place to live. And I think that right there is going to be the big piece, is her getting a place that is legally only hers so that she can remain separated from Charles, because there has been a trend of these incidents over the last several months. It wasn't isolated. It was consistent for quite a few months. And I have had discussions with Marcy, it was just last night, about maybe her moving towards where Messiah is placed, because she has a good relationship with her stepmother who has placement of Messiah to kind of give her a support system because she doesn't really have a positive support system in our area. So that's something that we're exploring as well.
Your Honor, unless I'm missing something, the court can, unless it already has, I don't know there's an order, but order Mr. McGuire out of the home. So yeah, it's his legal residence at this time, but I would imagine that court order would supersede that fact. We do it all the time. That's not a reason to keep these circumstances in place. It is just, given that the only issue here is a recent domestic violence, there's no substance abuse, there are no allegations of homelessness, there are not all the other circumstances we often see. It's domestic violence. She is the victim and she is engaged 100%. This is a very young child that's very far away. If my client's willing to move, that's great, but to suggest that just to keep this child out of this home, she should move 3.5 hours away is mind-boggling to me.
And how will I see my daughter?
Exactly. And Mr. McGuire, no, I know there are allegations that he's engaged in domestic violence, but there are no allegations that either parent has been harmful to the child. And I understand the DV is harmful to the child, but and the agency clearly can't assess or observe parenting time if these parents never get parenting time.
What the court does not want to have to do is remove a child twice. The child is stable, settled. Certainly, if I could be assured that return to mom would be, in essence, a permanent return without any need for further removal, I would be more sympathetic to that. But I don't have the comfort level that we're there yet. We're getting there. And what's really complicating this is the distance. I get that, but do I compromise a child for that sake? Mr. Kelly, I'd like to hear from you.
Yes, Your Honor.
What's your feeling on return home with a order removing Mr. McGuire from the home?
I guess my hesitancy is running into what we ran into with the case where the mother recently overdosed, where dad had the little child and kept letting mom run her back in the home. I is it the same thing would happen in this particular case, Your Honor? I mean, if agency feels it has enough assurances that that's not going to be an issue, I wouldn't have any strong objection to it. I just wouldn't want Messiah bounced into mom's home and then back out.
Your Honor, obviously I represent mom or did in the case Mr. Kelly referenced, and I understand the similarities, but that case has a very long history, as we know, and some very significant substance abuse issues. So it's not anything here. It's similar, but
Mr. Hotchkiss, you represent Mr. McGuire. What's your...
Honor, I do, and I haven't spoken with Mr. McGuire recently, but we have had previous conversations. I know he wants his daughter close where he can visit with his daughter. I know he also supports having his daughter return to the mother's care. I think that he would abide by this court's order to stay out of the home or do whatever is necessary so that Messiah could be in the home with the mother. And as it relates to the services, I think like mom, he began services before they were even ordered. And I think he is committed to doing what he can do to try to remain involved, but doesn't want to keep this child out of the home for any length of time, any longer than is necessary. And so I think that what Ms. McCluskey is asking for under the circumstances is reasonable. It's why we had an expedited a dispositional hearing so that this court could address and confirm the services that mom has completed. And to me, it makes sense to put this child back with mom. This is not like a drug use situation. If you keep Mr. McGuire out of the house with an order or something, that's much different than a relapse. And I don't know the case Mr. Kelly's referencing, but I have a hard time finding it analogous to this case. So Mr. McGuire will do what this court requires of him with respect to services, but I know he would request that his daughter's closer so that he can have visits, and that the daughter can be back in the home where she's comfortable and bonded and well known.
So I keep hearing that this is Mr. McGuire's home. Is he the only one that's on the lease here?
Mr. McGuire, are you the only one on the lease at your home?
Huh?
I'm in court. Cut that boat music. We're both on the lease,
Yes.
but he's agreed to stay out, and he's been gone. I'm sorry, I didn't mean to interrupt. I apologize.
I don't.
No. I
To the
asked
court.
a question.
To the court. To the court. I don't. You know, we had issues with the relationship when we was in a relationship. I'm willing to not live there. You know, I'm not living there now. I'm willing not to live there. I just want my daughter. I just want to see my daughter. That's it. You know, I'm not gonna put my daughter in any kind of harm or anything like that. If it means me having to go for my daughter to be somewhere where I know she's gonna be all right, so be it.
So Ms. Wright, if I were to enter an order removing Mr. McGuire from this home, would that, I mean, that's your primary concern, is it not? That he's going to return to the home and we're going to see this child exposed to domestic violence again?
That is the primary concern. I would like to see Marcy continue to work through these things and really like gain her independence to be able to be on her own without having to accept Charles back. But you're right. I mean, that is the primary concern.
This is one thing too. You don't know what's going on. You don't know what's going on with things, and you're just
McGuire,
speaking
do
out.
not interrupt. Do not interrupt.
Right.
Your Honor, it's my understanding that my client, it was her at her initiative that she was working with her case manager at Recovery Technology to find new housing. It's not my understanding that was the agency's suggestion.
No, but I did find it as a good solution for her.
Right,
once
but
it started.
now that you're now going to try to block the child to come home because now you want her to find new housing. That was never the agency's recommendation to begin with. That was her idea. So now we're using that almost against her.
But it's not so much the new housing as much as it's the legal, like, I guess the ordering him out of the home would be sufficient because it's the legal aspect of it that he can't go into her home. If she has her own lease, she can tell him he can't be there.
All right. I think I've heard enough. I am going to order the child returned to Ms. Rowe. I'm going to order Mr. McGuire out of the home. Mr. McGuire, if you go in or near this home, you are in danger of being arrested and put in jail. Any police officer.
So I can't see my daughter?
No, I'm not talking about that. I will certainly order that you get supervised parenting time with your daughter, but it's going to be supervised by the agency and it'll be at the agency. I'm not talking about your parenting time right now. What I'm talking about is your presence in this home. If you go to this home, whether the child is there or not, the police find you there, you will be arrested and taken to jail. Guaranteed. I'm going to implement the other recommendations. We'll set our next review hearing for May 11th at 8:45. Is there anything else the court needs to address today?
Your Honor, if I can interject, this is Sharmika March, Sam's supervisor, Samantha's supervisor. I just want to make sure that we make it clear to Ms. Rowe that does not mean that she can meet with Mr. McGuire outside of her home with the child, that he cannot see the child unless it's by way of the agency.
I will include
made that
in my
clear
order.
that I understand that.
All right, it'll be in
Thank
my
you.
order, Ms. Rowe. The only basis for me returning the child to you is assurance that the only contact that the father is going to have with his child is supervised visits by DHHS. You are absolutely not permitted to have him in the home. You are not permitted to allow him to have any contact with this child whatsoever, except as supervised by the agency. And that will be in my order. I want to make sure you understand that.
Yes,
If
sir.
there's a violation, of that, the child will be removed from your care, probably placed back in Bad Axe, because that's a place where the child is comfortable, and you'll have to figure the rest out on your own. So don't make me do that. I don't want to do that, but I want to make sure your child is safe.
I understand.
Okay, did I give you guys your next hearing date?
You said it was May
May 11th at 8:45.
May 11th.
All right.
So how do I have to wait for them to, do I go get her, or do they bring her back?
No. You'll be informed by Ms. Wright. She's the one that's going to be making the arrangements.
Okay.
I'll talk to you in a little bit, Marcy.
Okay.
Okay, I think we're done this morning.
Thank you,
Thank
Honor.
you all.
Thank you, Your Honor.
Have a good day.